Good afternoon, Miss Bridgewater.
Yeah,
You doing okay today?
I am.
Very
Hope
good.
you are too.
I am, thank you.
Very good. Our reset date is September the 30th.
Thank you.
Mm-hmm.
Courtroom two, if you'll just let me know when you're ready to proceed.
We're ready, Judge.
All right. Good afternoon, ladies and gentlemen. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. You have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. If you do not have a private attorney, we're providing you with the assistance of a public defender or conflict defender this afternoon if you choose to utilize their service. Where would you like to start first?
Go to position 13, Ms. Mobley.
Who's representing Mr. McLean? Good afternoon.
Good afternoon, Your Honor. I'll represent her.
Okay, good afternoon, Ms. Mobley. You have been charged in case 25 CR 005594C with battery family violence and simple battery family violence. Afternoon, Mr. Howard. Is there a history?
Hey, second arrest, 2016 battery DV. PTI was dismissed. If you choose to give us signature burn, this level 1 they had on there. That's all.
Thank you. Thank you. Good afternoon, Mrs. Rocco.
Good afternoon, Judge. This incident took place yesterday at 1659 Beerfield Run, Northwest Atlanta. This was a law enforcement responded to a domestic dispute call and made contact with one of the defendant's children. I will, just out of an abundance of caution, say Mr. Mobley, I believe he's of age, who he explained that the defendant, his mother, had been drinking and began to throw things around the house and pushed his older brother. Oh, excuse me. I thought it was his younger. The juvenile JM in the face, causing him to bruise under his eyes. The officer spoke to juvenile JM, who explained that the defendant had been drinking and angry and started to throw things around and then pushed him in the face. There was bruising and discoloration, as stated. The defendant was then arrested. Given the defendant's prior here with that previous case out of Forsyth, that battery family violence, from which she apparently didn't learn from the pretrial diversion opportunity that was afforded her. So the state's recommendation, born out of its concern for this victim, is a $3,000 surety, 2,000 on the battery family violence, 1,000 on the simple battery family violence, for the defendant to enroll in a complete FFIB, have no drugs, weapons, or alcohol while out on bond, random screens, and with respect to whether a no further contact or no further violent contact would be appropriate here. I would want to ask defense, are you aware whether the victim here has a place to stay or another parent to stay with?
I'm not aware of that. I didn't reach the victim, but I did reach the defendant's husband. And I believe that she lives with both children, and her ex-husband or separated or estranged husband does not. So if the child is okay with it, we would ask to simply have no further violent contact. I understand the children are quite well, they're wrestlers and can handle themselves. But Your Honor, Ryan, Mr. Shrocco, I've only reached James.
Okay. But there is that other, you said the ex-husband or the estranged husband, that is the father of the child here.
I believe that's correct, yes.
Okay. If that is the case, given the history here, we would be asking for no further contact. And that would be all we would sound for. I'm not sure his name, but the father of juvenile JM.
That'd be James.
If anyone's on the line that's related to this matter or wishes to address the court, now is your opportunity to do so. Mr. McLean? No, ma'am. Mr. McLean?
Your Honor, she is local, from Georgia all her life, with a stable address, has that one prior bachelor's in business, a BA in business, owns her own business for the last 18 years. Under these circumstances, considering what year that was, 2016, I believe, we would ask the court to consider a signature bond with appropriate conditions. If the ADET would be part of the appropriate conditions to help asking for a signature bond, we would certainly mention that into the mix.
Okay, for the battery, it will be a $4,000 signature bond through pretrial level 1. For the simple battery, a $2,000 signature bond through pretrial level 1 makes for a total of a $6,000 signature bond through pretrial level 1. 5 days of anger awareness, no further violent contact with the alleged victim, alcohol drug evaluation, any treatment that's necessary, random screens. And of course, no drugs, alcohol, or weapons while out on bond. Good luck to you, ma'am. We have Madam Interpreter on the line. Do we have someone who needs a Spanish interpreter this afternoon, I take it?
Peralta, which I think is number, what is that?
15.
15.
Yeah.
Okay, I'm just making you aware that Miss Chancey's with us, so however you can accommodate her.
I would
just
need
let me
to
know.
run into jail courtroom number 1 to do that real quickly if we could do other cases.
We have to wait.
We'll have to wait a bit.
Yeah.
Okay.
Okay, we'll be with you, Miss Chancey. Thank you.
Go to
You're
position
welcome, Eric.
14, Mr. Newkirk.
Good afternoon, Mr. Newkirk. You have been charged, good afternoon, sir. You have been charged in case 25 CR 005597J with disorderly conduct and criminal trespass. Is there a history, Mr. Howard?
42. On probation for 3 counts of ag assault, shoplifting. Got an open shoplifting out of the city, open possession of drug-related objects. We got a lot of probation violations. I saw a 2017 robbery arrest, 2015 shoplifting conviction. That's it.
Thank you. Mr. Sirocco?
Thank you, Your Honor. This incident took place, this was September 13th of this year at Krog Street Market. That's at 99 Krog Street, Northeast Atlanta. There was a response to a subject trespassing call, and the officer made contact with one of the security guards there. It is security guard Miss Daniels. Make sure I have Marquita Daniels. She explained the defendant, who had been previously trespassed from the property, had returned and was threatening the store manager here with a knife. Also threatened her, Miss Daniels, and the other customers, stating that he has HIV and would transmit it to them if they did not comply with his demands. The defendant did have a cutting instrument on him. It was a knife that was recovered. He was placed under arrest at that time. I believe pretrial stated this, but he has over 40 cycles. I should mention escape conviction. He was arrested in Miami in 2022 for being an out-of-state fugitive from Fulton County. So there's a risk of failing to appear here. And as presented here in the warrant, I mean, this is really concerning behavior. The state's recommendation here is a $4,000 total surety on the disorderly conduct, 3,000, and criminal trespass, 1,000. Stay away from the Krog Street Market, all of Krog Street Market. No further contact with Miss Daniels, and again, that is Marquita Daniels. Surrender any and all firearms to the sheriff's, any and all weapons to the sheriff's office, and no drugs, weapons, or alcohol while out on bond.
Thank you.
Also, it might be relevant and important as well for a social worker visit for BHET and or housing here.
Thank you, Mr. McLean.
Your Honor, he's 51 years old, has been associated in the past with PAD. So I've left a message with PAD to get hold of us, even though they do cases which are not accused. Your Honor, he's been through the DeKalb County school system and high school. He asked the court to set the bond as low as possible in this situation. We do have contact information in addition to PAD, though, which I've left a message at. He's active with a certain church on Boulevard near the King Center, so that's pretty local. And so we'd ask for the lowest bond possible in this situation, Your Honor.
And for each charge will be $1,000 good bond, makes for a total of a $2,000 good bond. Stay away from Krog Street Market. No further contact with Marquita Daniels. A social worker visit to assist with housing or BHET. No drugs, alcohol, weapons while out on bond. Good luck to you, sir.
Thank you, Your Honor. Thank you.
Thank you, Your Honor, so much.
No, it's not.
Okay.
No.
You can go to position 2, Mr. Barnes.
I actually would prefer a breakout room for Mr. Barnes, if that is possible.
Ms. Wells, good afternoon. Can we just hold Mr. Barnes until the end of the calendar and then go off the YouTube feed? Would that suffice, Ms. Wells?
Yes, thank you. Thank you.
Okay, so can we hold Mr. Barnes until last, please?
Yes, sir.
Okay, thank you.
Go to position 5, Mr. Clark.
Good afternoon, Mr. Clark. You have been charged in case 25 CR 005587B with simple battery family violence. Is there a history, Mr. Howard?
No.
Good afternoon, Ms. Paul.
Yes, Your Honor. Good afternoon. You'll just give me one moment. Apologize, I didn't realize my ringer was still on. This incident happened on September 13th of 2025. Alicia Jeffries called police out to 3200 Lakeview Place, apartment 310 in East Point. The Miss Jeffries stated that she had gotten into a verbal altercation with Brandon Clark, who is her stepfather, and it resulted in the defendant pushing her to the ground and restraining her onto the ground. She advised that, let me see, there were no injuries that were actually observed between the two individuals. And when they spoke with the defendant, they asked him if he did strike Miss Jeffries with an open hand. He advised he did neither, but he did admit to pushing her and restraining her. And he also stated that he went overboard. And when he was asked by the officer what that meant when he said he went overboard, he stated that he pushed her too hard because he was angry with her. At that point, the officers did place the defendant under arrest. I understand that this is a first offense. We are agreeable to an SOB through pretrial services as long as there's parenting classes and anger awareness attached to that, given these circumstances. We are also asking for no further violent contact with Alicia Jeffries and no alcohol, drugs, or weapons. We would like to sound for Miss Jeffries if she is here, or the parent of Miss Jeffries if she is here. I did have a our office did have a conversation with Miss Clark, who is the mother of Miss Jeffries. She stated the defendant is her husband and her daughter. She stated that the defendant was trying to break up a fight between her and her sister, Miss Jeffries, and Miss Jeffries' sister, and her daughter took the situation out of hand, which is contrary to what even the defendant acknowledged he had done. She claimed he is not a bad person, was just trying to break up a fight. And again, that is contrary to even what the defendant himself said, which is that he overreacted and behaved and did push her, which because he was angry with her, not because he was trying to break up a fight. That's all for the state.
What's the wife's name, Ms. Falk? Sorry.
Clark. Her name is Amber Lee Clark.
If Miss Amber Lee Clark is on the line and wishes to address the court, now is your opportunity.
Yes, can you hear me?
Okay. Yes, ma'am, I can hear you. Good afternoon, ma'am. Can you raise your right hand for me?
Yes,
Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
yes,
Okay, you can place your hand down, Ms. Clark, just so that I'm, so you are Brandon's husband and Miss Jeffries' mother, is that right?
yes.
And how old is your daughter?
15.
15? Okay. Yes, ma'am. What would you like to tell the court?
Yes, my daughter, she is a troubled teenager. She went from being bullied to learning how to fight and defending herself and getting suspended multiple times from school. And she failed 2 classes, and she's currently in her 10th grade year of high school. So we've had a lot of issues with her, but again, it stemmed off of bullying. But she has a bad attitude problem, and we basically walk on eggshells in this house, around her. It's rough. I'm doing my best to try to, get it together, reel her back in, because she wasn't always like this. But her sister talked to the cops as well and told them, and she explained to me it stemmed from them getting into a fight, but all over her looking for some hair glue, and she tore up the room and was throwing stuff all over the place. And my other daughter was working on a project for school, because my other daughter is the total opposite. She's straight A student, all honors classes. She's in her senior year of high school. But they got into an altercation, and so he was sitting down playing his game. He was relaxing on his off day and heard the commotion and got up and went to go and handle this to see what was going on, basically. And he saw what was going on, and was fussing at her or whatever, and things just escalated. But it's a lot of us dealing with this stuff on a daily basis, yearly. It's been going on for a while now. And I'm not excusing his behavior, but I'm just saying, I'm to a breaking point myself, and it takes a lot for me to deal with her every day. But I'm trying not to give up on her. And he's never done this before. He's been in her life since she was 3 years old. He's been more of a father than their actual father. So, you know, it really hurts me that he's in this situation because he does so much for them. He takes them to school every day because I have to be to work really early in the morning. But he's been there for them. He's the one who helps me take care of them financially. You know, he's their basically their dad. So I just, you know, this is just my child just needs some help, you know, and he just, it's been a lot, I understand he took it too far, but it's been rough.
Okay, thank you, Ms. Clark. I appreciate you being here.
No
Yes,
problem.
Your Honor,
yes,
I
Ms.
just have
Clark.
one follow-up question. And Miss Clark, if I may, you weren't present for any of this, correct?
No, I was about to get off of work when, he called me initially looking for my child because she had left the house. After the altercation, she had ran out the house. So he was looking for her and called me to let me know literally literally almost at the exact time I was getting off work because he was actually out there looking for her or whatever.
And when he spoke to you, based on the police report, isn't it correct that he told you he went overboard when disciplining AJ?
I would object to that question. This is a bond hearing, and I understand
Your
you're going to
Honor,
ask the question. I'm going to object.
I understand, I understand the situation, so, thank you.
I still would like it for the record, Your Honor. Miss Clark?
Yes, he did.
Okay,
He said
thank
that
you.
he said, and he apologized, and he said that he kept saying, "I'm
I would
sorry."
object to the further explanation beyond outside of answering the question. The question was answered.
I understand the situation, Ms. Clark. Thank you for being here this afternoon, ma'am.
No problem. Thank you.
Yes, Ms. Wills.
Your Honor, I am in agreement with the signature bond. I would object to the anger management and parenting class. As Ms. Clark has stated, Mr. Clark has been there for both of her children. He's stepfather of both of her children. He is employed. He's an active father. And speaking with Ms. Clark, I did have the opportunity to speak with her prior to today's hearing. She feels safe. She wants him to return home, and did acknowledge that her daughter has some behavioral issues that they have been working on and working through. And so in light of that, I'm in agreement with the signature bond. I would object to any sort of classes at this time.
And I understand that it might be a difficult situation. I don't think that a parenting class or that anger management will be hurtful, and it might enlighten in some ways to be able to deal with the 15-year-old. So with that said, it will be a $2,000 signature bond through pretrial level 1, 2 days of anger management, 1 parenting class, no further violent contact with the alleged victim, and no drugs, alcohol, weapons while out on bond. Good luck to you both.
Thank you so much.
You're welcome. Who do we have next?
Your Honor, position 12, Ms. Naya Lewis.
Okay, good afternoon, Officer Milton. Ms. Lewis, good afternoon. You have been charged in case 25 CR 005596C with battery family violence and simple battery family violence.
Your Honor, I'm sorry. Before we proceed, this is a dual arrest case.
Okay.
It is
Derek Carter.
Derek Carter. Yep. If we could hear, if we have Mr. Carter, if we could have both cases, that would be ideal, I think.
All right, thank you, Mr. Sirocco. I take it Mr. Carter's here in courtroom 2.
And I represent Mr.
Okay, so you represent Mr. Carter, Ms. Wills, and Mr. Murphy. You represent Ms. Lewis?
Yes, Judge.
Okay, good afternoon. Let's see. Good afternoon, Mr. Carter. You have been charged in case 25 CR 005595Y with 2 counts of battery family violence and 2 counts of simple battery family violence. Mr. Howard, let's start with Ms. Lewis. Is there a history? Okay. And what about for Mr. Carter?
19. He on probation out of Douglas County for trafficking a controlled substance. 2 counts. 2022 failure to appear. That's all.
Sirocco?
Thank you, Your Honor. This incident took place yesterday. This is at 1395 Kennesaw Drive Northwest in Atlanta. Law enforcement responded to a physical altercation and made contact with Nia Lewis, who explained that Mr. Derek Carter, her boyfriend, who lives with her there, that he was sending her text messages while she was out at the club, partying and drinking, about releasing the dog to roam or while she was out late. And when she returned to the location around 3 a.m., was met by the defendant, who she says was hassling her about being out late clubbing, and that this led ultimately to physical violence. There were exchange of blows between the two, as Miss Lewis stated, and she states she tried to push him away from him charging at her. And when law enforcement spoke to the Mr. Carter here, she had said that the other individual, Miss Lewis, had returned home intoxicated and had become combative because he wanted her to leave the house. And she said, "I will when I want to." Jabbed her finger in his face, and there was a physical altercation that ensued from that. Uh, Visible injuries observed on both parties here in the form of bleeding, swelling on Miss Lewis's finger and a cut on the Mr. Carter. Unable to determine a primary aggressor at this point, but given their respective histories for Miss Lewis, the state's recommendation is a signature bond through pretrial services. 2-day anger awareness, no further violent contact with Derek Carter, and no drugs, weapons, or alcohol while out on bond. As for Mr. Carter, the state's recommendation, given that 2022 FTA is a $1,500 total surety, 500 on each of the battery family violences, and $250 for each of the simple battery family violences. 2-day anger awareness, no further violent contact with Nia Lewis, and no drugs, weapons, or alcohol while out on bond.
Mr. Murphy?
Judge, she has no priors. She is an Atlanta native. Judge, and just to reassure the court, if you would go along with the state's recommendation of the signature bond, we don't have any issues with 2 days anger management. My client would relocate to her mother's residence in Coweta County. These parties do not have any children together. They do not work together, and they would not really be associating with each other if they're now living in different residences. My client did have a few drinks and is an entertainer by profession, and unfortunately there was a disagreement. But again, we'd ask that you allow a signature bond, Your Honor.
Ms. Wills?
Thank you, Your Honor. I'm in agreement with Mr. Murphy in as much as I would request that my client be allowed to return back to the residence, as that is his home, and it seems that the co-defendant is in agreement with that. I would ask for a signature bond, if not a signature bond, the lowest bond that you would order in this case. My client states that he was attacked, that any injuries that were observed on the cross defendant came from her attacking him, and that there was no physical contact that he was the aggressor of toward her.
So the battery will be $2,000 signature bond through pretrial level 1. For the simple battery, $1,000 signature bond through pretrial level 1. Makes for a total of a $3,000 signature bond through pretrial level 1. 2 days of anger management. No further contact with Mr. Carter. Stay away from the Kennesaw Drive address. She can go back to that address on one occasion with law enforcement to retrieve any belongings. No drugs, alcohol, weapons while out on bond. For Mr. Carter, position number 3, for each of the batteries will be a $500 good bond. For each of the simple batteries will be a $250 good bond. Makes for a total of a $1,500 good bond. No further contact with Ms. Lewis. No drugs, alcohol, weapons while out on bond. Good luck to you both.
Thank you, Judge.
You're welcome.
Your Honor, I hate to do this to you, but you were breaking up so bad.
Okay, well, if I am, just stop me in the middle if you can't hear me so that
Okay,
I
so
can make
if
sure
you,
that
if
you
you
get
would,
me.
yes,
Okay, so for position 12, the
okay,
battery is 2,000 SOB, the simple battery is $1,000 SOB. 2 days anger awareness, 2 days anger awareness,
uh-huh,
stay away, no
okay,
further contact,
okay,
one-time escort.
okay.
Okay,
Got that one. Now go back to Mr. Carter.
for each of the family violence was $500
Okay.
batteries, $500 good bonds.
Yes,
For each of the simple battery at 250, good bond, no further contact, no drugs, alcohol, weapons.
thank you. Was there
Yeah.
not 2-day anger awareness with him?
No, there was not.
Okay, thank you.
You're welcome. Who do we have next?
Next is position 4, Mr. Chambers.
Okay, good afternoon, Mr. Chambers.
You doing?
You doing well, thank you, sir. You have been charged in case 25 CR 005586H with theft by taking. Is there a history, Mr. Howard?
Third, 2023 fade to appear. 2022 entering auto dismissed. That's
Thank
it.
you. Ms. Falk?
Does it indicate where the failure to appear was from, Mr. Howard?
I didn't put it in my notes.
Okay, I can double check. I think I didn't put the location in my notes that I had. Your Honor, this occurred on June 3rd, 2025. Officers were called out to 1200 Center Parkway, which is Lincoln Technical School, in regards to a theft. It's Lincoln Technical Institute. They spoke with the program chair, who stated on June 3rd, 2025, at approximately 8:15 p.m., one of his students stole several pieces of equipment from the location during the evening operation hours. There were impact sockets, a battery jump box, an AC leak detector, and a jack stand. The total value was $1,100 of items stolen. Officers then reviewed, and the school reviewed the video footage and observed a white in color Cadillac sedan being directed in the working area of the business by the defendant. In this case, shortly after entering the work area, the defendant is seen checking out the keys for the toolbox along with other items from that designated area. And he's seen placing several tools inside of the vehicle, which is how the defendant was identified as the person who had stolen those items. The defendant currently has an FTA from, Your Honor will just give me a moment. It looks like that FTA was out of Fulton County in 2023. So it has been within the last 2 years. Yes, Your Honor?
I didn't say anything.
Oh, I apologize. I think I heard some feedback. So it has been within the last 2 years. For that reason, he is ineligible for a unsecured judicial release through the jail. We would ask for $1,000 surety bond, stay away from the location of the Lincoln Technical Institute at 1200 Center Parkway in East Point. No alcohol, drugs, or weapons, and no further contact with Randy Bobzian, that is Bobzien, who is the program chair of that institute. That's all for the state.
Ms. Wills?
Your Honor, I would request a signature bond in this case, or the lowest bond that you would be so inclined to order. My client does state that he has been recently struggling financially, and also his newborn daughter also passed away, so he's been having some personal struggles. But he does deny the allegations, and is unable to afford any bond at this time.
Okay, will be a $5,000 signature bond through pretrial level 1. No further contact with Mr. Bobzian. Stay away from the Lincoln Tech Institute. No drugs, alcohol, weapons while out on bond. Good luck to you, sir.
Next is position 7, Mr. Hayes.
Good afternoon, Mr. Hayes. You have been charged in case 25 CR 005589C with battery family violence, simple battery family violence, and cruelty to children in the 3rd degree. Is there a history, Mr. Howard?
45. You got an open battery DV, 2 of them. It's 25 CR 002338C. 25 CR 002337C. 2021 ag assault, kidnapping, arrest. 2017 fade to appear. 2015 simple battery conviction. That's it.
Ms. Falk?
Yes, Your Honor. This incident happened June 17th, 2025. Officers were called out to 1006 Sim Street Southwest. They spoke with Miss Constance Mason, who stated that she had moved to this new residence to escape the defendant who had been previously arrested for another incident involving the 2 of them. Miss Mason also interestingly told the police that as a condition of his bond, they were to have no further contact. She stated that approximately 4 p.m. that on the 16th, the defendant broke through a back window of her home. He tried to have sex with her in an attempt to force himself on her. She expressed she did not wish to have any kind of intimate relationship with him, and he became violent. He began striking her in the face. She was able to break free from him, and her cousin transported her to Emory University Hospital. She did sustain, as a result of this, a busted nose with blood, a busted lip, and officers also observed bruises on her inner thigh, which corresponded on both of her inner thighs, which corresponded to her earlier statement regarding his attempt to force himself on her. The officers did take pictures of the injuries and uploaded them. She also stated that her daughter, CM, who was at the time of the incident 8 years of age, and her niece, who at the time of the incident was 11 years of age, were present during the incident. Additionally, at the time of this incident, Miss Mason was pregnant. She has since had the child, who is now 12 days old. We are very concerned in regards to this, Your Honor, especially because Your Honor is the judge that issued both of the surety bonds on his family violence battery cases against Miss Mason, one of which occurred in February 15th of 2025, and one of which occurred on, January. I believe the other incident was in January of 2025, January 21st of 2025. The January 21st, 2025 incident was alleged he struck her in the face several times, causing small cuts to the upper part of her lip. And that was after an argument. And then in the February 2025 incident, he struck her in the face with a clenched fist twice that caused swelling to her forehead. That was also due to an argument where the defendant began to accuse her of infidelity. And so this is now the 3rd instance in the last 7 months involving violence to Miss Mason. Your Honor issued a $1,000 surety bond on May 5th, 2025 on case ending in 3337C. And with a no further contact with Miss Mason, stay away from her old address, which was Old Hateville Road, no alcohol, drugs, or weapons. And on the second case, Your Honor issued a $1,000 surety bond on the family violence battery ending in 338C, also with a no further contact, stay away, no drugs, alcohol, and weapons. I will say that Your Honor issued both of those orders on May 5th, 2025, and this incident happened in approximately 1 month after Your Honor had issued those bonds. So clearly there is not any indication that he is going to continue to follow the orders of this court or continue to comply with them. We are asking for a $6,000 cash bond. $3,000 on the family violence battery, $2,000 on the family violence simple battery, $1,000 on the cruelty to children in the third degree. We did have an opportunity to speak with Ms. Hayes. Ms. Hayes actually told the victim witness advocate she does not understand why she was calling about an incident for which he has already been arrested. And I think that really speaks to how, quite frankly, sad this situation is, because the defendant hadn't been arrested on this case yet. She was literally confusing this instance of abuse with the prior instances of abuse that he had been arrested on. And I really think that speaks to really the tragedy of all this, and the fact she is truly caught in a family violence battery cycle that she is not able to escape on her own. And so that is why the state is asking for a cash bond on this case. We would like to sound from Ms. Constance Mason at this time, and that's all for the state.
Ms. Falk, if you wouldn't mind, go ahead and send those other case numbers to Ms. Bridgewater for me, please.
Yes, Your Honor, I will.
Thank you. If Miss, is it Constant Mason Hayes? What is the name, Miss Falk? Is it Hayes or Mason?
Mason. No, her last name on all of the police reports has been Mason.
Okay.
I'm not sure if they have subsequently, it didn't indicate they have gotten married or taken any of those steps, but her name is Constance Mason, according to all of the documentation we have.
Thank you. If Miss Mason is on the line and wishes to address the court, now is your opportunity. Doesn't appear so. Mr. Murphy, is this your case?
It is, Judge. And in fact, he was picked up on a traffic stop. He's not aware of this incident. He's lived in Atlanta his entire life. He's a ASC certified auto mechanic for the past 17 years. He's with A1 Mechanical in the city. He has a separate residence nowhere near this alleged victim. I'd ask for a reasonable bond under the circumstances, Judge.
For the battery, it will be a $2,000 cash bond. For the simple battery, $1,000 cash bond. For the cruelty, $1,000 cash bond. Makes for a total of a $4,000 cash bond. No further contact with Constance Mason. Stay away from her residential address. No drugs, alcohol, weapons while out on bond. If he doesn't get out, I will see him back at the SAP calendar on September 30th. And Ms. Bridgewater, if you'll just make note to put all those cases on that calendar for me, please.
I will.
Duly noted, Judge. Thank you.
Thank you. Your client has his hand up. Mr. Hayes, Mr. Murphy will get in touch with you at some point after this court session.
That is correct, Judge. I'll be reaching out to his family.
Thank you. He still has his hand up. Mr. Hayes, you have a right to remain silent. Anything you say can be used against you. Do you want to advise him, Mr. Murphy?
Yes, Mr. Hayes, given the circumstances, I'd advise that you make no statement other confirming what your name is, who your name is, and make no other statements. I can address anything else through your family and phone calls. I would advise you to remain silent.
Doesn't sound like you appear to want to remain silent. So courtroom 2, if you will unmute yourself. Again, Mr. Hayes, you have a right to remain silent. We're not litigating this matter today. This is just a bond hearing. So your attorney is...
But sir, I'm saying this is out of hand, sir. I do not live with this young lady. This is the second opportunity. She's done this several times. She continues to lie to the police, then come to the court and say that she's crazy. She didn't take her medicine. She don't know. I haven't seen this woman. I'm
here trying to speak about it.
She's right here. My girl, all my clothes, all my things is there. My birthday is in July.
Praise.
Seen this lady, nope, since May. I don't know. She's saying all these different things, and it's beginning to be a problem because there is no way possible someone could just lie and say you did something to them and have you arrested, and none of these things have happened. The last time it happened, she came to court, say she didn't take her medicine. She's crazy. She this, that, and the third. She don't recall. They gave me a bond. I bonded out. I ain't seen this lady since. 3 days, 4 days later, I don't answer my phone for her. she put another charge on me. I haven't seen her. I don't put my hands on women. I'm 40 years old.
I came to court to let them know.
I don't have a history of.
Okay, hold on, Miss,
I'm 40 years old. I don't have a history of putting my hands on women. I don't have a history of any of these things. I can't make a cash bond. I'm asking for a signature bond or
And I'm sorry, I didn't mean to do
some
this
of
to
that
you.
nature. That's fine. I understand that. Whatever.
Courtroom two, if you'll mute there for a second, thank you. Now, I see a Miss Cassandra Hayes. Are you the same as Constance Mason?
Yes, sir.
Can you come on camera for me?
I have my child breastfeeding.
Well, I'm gonna need to see you if I'm going to, is there somebody there that can take care of your child while you are in this court session?
My kids need me. I'm the only person they have.
So you're telling the court no, that you don't have someone there that can take care of your child?
Not right now.
Okay. Ms. Falk, I will need for the victim advocate to reach out to Ms. Hayes. Mr. Murphy, if you will look into this matter, I am willing to, I'm gonna leave the bond where it is, but instead of the hold on, instead of the SAP calendar in 2 weeks, Ms. Bridgewater, would you put this on my SAP calendar for the 23rd?
Yes, I will.
Okay, so Mr. Murphy, would you do your best to look into this and so that I can, if necessary, reconsider it at that time? Ms. Falk, if you will have your victim advocate report back to me at that SAP calendar so that we can possibly sort this out.
Yes,
Okay.
Your Honor.
Thank you. I'm going to leave the bond where it is at the present time, but if a modification is necessary, I'll consider that. Okay, so that's the best that we're going to do for you this afternoon, Mr. Hayes. Okay, but I will see you back in a little over a week if you don't make bond. Okay, Mr. Murphy will be able to speak with you. Okay, I understand your situation, sir, or what you're telling me your situation is.
I'm sorry.
You're free to go, Ms. Hayes. Okay, we're not going to resolve this today. So courtroom 2, let's go on to the next person. You're going to hear from your lawyer, Mr. Hayes. 2.
Come on. Next is position 16, Mr. Simmons.
That's mine, Judge.
Okay.
Shit, sir, I can't make.
That is the first arrest that I have.
Thank you. Thank you. Good afternoon, Mr. Simmons. You've been charged in case 25 CR 005599A with 3 counts of simple battery family violence. My understanding that this is Mr. Simmons's first arrest. Yes, Mr. Sirocco.
Thank you, Your Honor. This incident took place September 12th of this year. It was at 630 Amal Drive Southwest in Atlanta. Law enforcement responded to a dispute call and made contact with the victim here, Miss Kalima Ali. That's Kaalimah, who explained that the defendant, her boyfriend, and the father of their child, a 4-month-old, had become upset over accessing her navigation and saw that it returned an address to an ex-boyfriend's work location. The defendant came home aggressively and confronted her about that situation, shouting in her face, and she was trying to create distance between him when he then pushed her onto the bed where their infant was lying, and he held her down and then bit her on her left cheek. The victim's mother came into the room and actually told them to stop, at which point the defendant released her. So we are grateful that she was there. Excuse me. The defendant notably admitted to grabbing the victim and then pinning her to the bed, stated he was not in fear for his safety when he did so. We have not spoken with Miss Ali yet. We would, of course, ask the court sound for her when appropriate, but we'll be asking for a signature bond through pretrial services here. But with this having taken place just a few days ago, and over a jealousy incident, and with us not having been able to speak with the victim about this, we are recommending no further contact whatsoever with Miss Ali. Stay away as well from 630 Amal Drive Southwest in Atlanta. FIB and no drugs, weapons, or alcohol while out on bond. And again, if we could sound for Miss Ali at this time.
Hi, Miss. The victim is on. The victim is on, so she can speak for herself. This is his older sister, Evita.
Okay, all right, hold on, ma'am. I see that Miss Ali is here, so I'm gonna, Miss Ali, if you would like to address the court, now is your opportunity to do so, ma'am. If you,
Okay.
okay, hold on. Raise your right hand for me, please. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. What would you like to tell the court?
Basically, we did have a verbal altercation. And one thing did lead to another, but he doesn't have a past. This normally doesn't happen. We just a couple that had a disagreement, and I feel like he should not be in there. And that's pretty much it.
Okay, do you want him to come?
He's never raised his hand at me. He's never wounded me in a way, where I have to go to the hospital or nothing. He's never physically abused me at all. So for just the pin down to happen, that was just, maybe he was just extremely upset, but that's never happened.
Okay. Did you call the police?
I did not.
Was it your mother who called the police?
That is correct.
And she stopped this incident from going any further, correct? She came in?
Right. She walked in right after. So she didn't witness him pinning me down to the bed.
But he did pin you down to the bed, correct?
Correct.
All right. No further questions.
You done, Mr. Srocco? Okay.
Yep.
Mr. Murphy.
Judge, I don't believe any alcohol was involved or any drugs. My client is age 33. He is a banker. He's a university graduate. He's been with a prominent bank for the last 3 years, but he's been a banker almost 7 years. He attended at university in South Carolina State University. They do have a 3-month-old together. We would ask for a signature bond. Judge, I believe he's the sole support system for the alleged victim and the 3-month-old child. I believe FIP might be a little bit too onerous at this point. If we could leave that at maybe a couple sessions of anger management, given there's really no history, and allow us a signature bond with further contact, allow them to live together. I don't believe there's any other issues that would become problematic. My client would acknowledge that there was a disagreement and perhaps he was reacting to some offensive gestures, but nothing more, nothing less, Judge. And I'd ask you to consider allowing them to reside together and allow a signature bond under those circumstances. I'm familiar with the banking industry. Unless you have time off, they're going to fire you if you're not back on the job real soon. So again, we'd ask for his signature.
Okay, it will be $1,000 signature bond through pretrial level 1 on each charge. Makes for a total of a $3,000 signature bond through pretrial level 1. 2 days of anger management. No further violent contact with Ms. Ali. No drugs, alcohol, weapons while out on bond. Good luck to you both.
Thank you, Judge. We appreciate the grace of the court.
Thank you.
Judge,
You're
that's
welcome. Have a good afternoon, Mr. Murphy. Thank you.
Go to position 15, the Batista. Spanish interpreter.
Okay, and this is the I'm sorry, the interpreter case, is that right?
Yes, Your Honor.
Yes, Your Honor.
Okay, thank you. Good afternoon, Ms. Chance. If you'll raise your right hand for me, do you swear or affirm that you will interpret from English to Spanish and Spanish to English to the best of your ability?
I do, sir.
Thank you. Good afternoon, Mr. Batista. You have been charged in case 25 CR 005598H with theft by shoplifting.
Buenas tardes, señor Batista. Usted ha sido acusado en el caso 25CR005598H con un cargo de robo de tienda.
Your history, Mr. Howard.
¿Hay antecedentes, señor Howard?
2023 driving without a valid license conviction.
En el 2023 hubo una convicción por manejar sin licencia.
2023 illegal alien.
También en el 2023 un cargo por inadmisibilidad de extranjero.
And jail was the recommendation.
Y la recomendación fue cárcel.
Mrs. Rocca.
Thank you, Your Honor. So this incident took place March 26th, 2024 at Target. It's the one located at 1135 Woodstock Road in Roswell. Law enforcement
Gracias,
responded.
su señoría. Este incidente ocurrió el 26 de marzo del 2024 en una tienda Target, la que está localizada en el 1135 de Woodstock Road en Roswell.
Law enforcement responded to a theft call, and the officer met with loss prevention officer Joseph Roach.
La fuerza del orden respondió a una llamada de robo. El oficial se reunió con los oficiales de prevención, Joseph Roach.
He explained to the officer that there were a number of individuals observed gathering grocery items and personal hygiene items and filling shopping carts with them.
Él explicó al oficial que un número de individuos que se observaron juntar comestibles y también limpiadores, artículos de limpieza, y llenaron los carritos con ellos.
The shopping cart with the merchandise that was filled up as relevant here was roughly worth $235.
Los, los carros de mercadería que se llenaron era importante porque reunían un valor de $235.
That merchandise was pushed on a cart out the store without paying for the merchandise and was placed into a white Kia vehicle.
La mercadería fue empujada en el carrito fuera de la tienda y sin haberse pagado los artículos, y se colocaron en un Kia blanco.
The information provided by from a search of the vehicle, a search for the vehicle, that helped lead the officers to the defendant's ID, and that his driver's license was checked with the still shots from the camera footage from the target, identifying him as the defendant.
La información que se entregó de un registro del vehículo ayudó a los oficiales a obtener la identificación del acusado. Esta licencia se chequeó con los fotografías que había tomado la cámara de la tienda Target, que identificó a este acusado.
Given the defendant's arrest history, that 2023 illegal alien arrest, the state would argue he does not have sufficient social ties here, which is a concern. So we would be asking for a $1,000 surety on this, and I'll proceed with the rest of the conditions shortly.
Dado a que el historial o antecedente penal del acusado, por ejemplo, en el 2023 tuvo inadmisibilidad de extranjero, un arresto, la fiscalía objeta que no hay, él no tiene suficientes contactos en la comunidad, lo que es una preocupación dado a que por eso se piden o solicitan $1,000 de fianza bajo garantía.
Uh,
Y, oh, go
Apologies.
ahead, sir. I'm sorry.
The state also recommends stay away from the Target at 1135 Woodstock Road in Roswell, and no drugs, weapons, or alcohol while out on bond.
Entonces, la fiscalía recomienda que distanciamiento de la tienda Target localizada en el 1135 de Woodstock Road en Roswell. Se prohíbe el uso de drogas, armas y alcohol mientras esté libre bajo fianza.
And that is all for the state.
Eso es todo de parte de la fiscalía.
Mr. McLean.
Thank you, Your Honor. My client is 55 years old and states that he's lived in the metro area at least a couple of years, going on 2.5 to 3 years, and has community contacts in that he lives here, and that was a Decula or Duluth address, I believe. And he has worked in the logistics industry, as I would refer to it, such things as DoorDash or Uber or Lyft or taxi type things.
Mi
So,
cliente tiene 55 años de edad y declara que él ha vivido en el área de Atlanta metropolitana por lo menos un par de años, casi tres, y también tiene contactos dentro de la comunidad. Y él vive aquí, ahora, en el área de Dácula o Duluth, creo. También él ha trabajado en la industria de logística, como me refería, como por ejemplo para DoorDash, Uber, Lyft, o cosas relacionadas también a manejar o conducir un taxi.
given the $200 and something alleged amount of the total shoplifting that is alleged here, given that there were 5 individuals who were said to have been part of this, given the 2023 allegation about or information rather, about the no license business, we would ask the court to consider, under these circumstances, a signature bond.
Entonces, dado a los 200 y algo más dólares de valor de el monto alegado de este robo en la tienda, en esta demanda, también el hecho en que hubo 5 individuos más que tuvieron parte en este hecho, y también que en el 2023, considerando el alegato de anterior o la información que está provista, em, sobre no tener la licencia válida, quisiéramos pedir que el juez considere darle bajo estas circunstancias una fianza bajo firma.
Given that on the booking screen, it's showing right now a $2,500 surety bond, in the alternative, if the court cannot grant a signature bond, then I would think a $1,000 surety bond would be the next best request from us.
Dado que el informe oficial en el sistema muestra una fianza bajo garantía de $2,500 establecida, quería solicitar una otra alternativa. Si no puede otorgar esa fianza, solicitamos una fianza bajo firma de 1,000, pero si no se puede, una fianza bajo garantía de $1,000.
The only third alternative I would suggest logically would be a cash bond of $240.
Y la otra alternativa que sugiero, lógicamente, sería una fianza bajo dinero de efectivo de $240.
Thank you.
Gracias.
Okay, will be a $5,000 signature bond through the jail. Stay away from the Target on Woodstock Road. No drugs, alcohol, weapons while out on bond.
Será entonces una fianza de $5,000 bajo firma a través de los servicios de la cárcel. También mantenerse distanciado del negocio Target de Woodstock Road y queda prohibido el uso de drogas, alcohol y armas mientras esté libre bajo fianza.
Good luck to you, sir.
Buena suerte, señor.
Do we need Madam Interpreter for any other cases this afternoon?
I wouldn't think so.
Okay, thank you, Ms. Chancellor. We
You're
appreciate your help as
welcome.
always. Have a good
Thank you so
afternoon.
much. Have a good evening, sir.
Next is position 19, Miss Tally.
Good afternoon, Ms. Talley. You have been charged in case 25 CR 005602C with 2 counts of battery family violence and simple battery family violence. Is there a history, Mr. Howard?
11. 2019 shoplifting NOD. It's level 1 if you do it. That's it.
Mr. Sirocco?
And this is
Yes,
Mr. McLean's case. I believe he may need some time to get back to courtroom 2.
Okay.
Okay, thank you.
You're welcome.
In the meantime, we can go to position 1, Mr. Arnold.
Good afternoon, Mr. Arnold. You have been charged in case 25 CR 005584E with simple battery family violence. Is there a history, Mr. Howard?
3rd, 2015 suspended license, 13 DUI conviction. That's it.
Yes, Ms. Falk.
Yes, Your Honor. Just give me a moment. This incident happened on September 13th of 2025 at 4460 Old Fairburn Road in Atlanta. Officers responded to that location and spoke with the victim in this case, Rhonda Carter, who was living with the defendant. They'd had a disagreement, and then the victim came outside while speaking to the officer. The victim came outside and began yelling, "He hit me." She stated that the defendant had backhanded her in the mouth. The officer then returned to speaking with the defendant and asked him if he had slapped Miss Carter. The defendant said he had. At that point, he was handcuffed and taken into custody based on his admission to striking Miss Carter. As you've heard, this is the defendant's 3rd offense. I do not believe the defendant has any violent previous offenses. The state would, let me just double check one more thing. The state, I do not believe, had an opportunity to speak. We did not with Miss Carter in this offense. Given the less than 48 hours that has elapsed since the offense, we are asking for a $2,000 surety bond. We are also asking for no further contact with Rhonda Carter and that the defendant stay away from the address at 4460 Old Fairburn Road in Atlanta. No alcohol, drugs, or weapons. At this time, we would like to sound for Miss Rhonda Carter if she is present and would like to speak. That's all for the state.
If Ms. Carter is on the line and wishes to address the court, now is your opportunity. Does not appear so. Ms. Wills?
In light of my client's limited history and lack of any violent history, I would request a signature bond. My client does state that the alleged victim is a friend of his, that the residence where this alleged incident occurred is his residence. So I would ask that he be allowed a one-time police escort. And also, if she is not residing there, that he be allowed to return to his property. I do understand if there's going to be no further contact provision, and if she stays there, that he would have to leave. But I am asking for at least a one-time police escort to pick up his belongings and to see whether or not she is still there. My client is currently unemployed, and so he is unable to afford any bond at this time.
And Your Honor, I would like to point out that in the warrant, it was the defendant that described Miss Carter as his living girlfriend.
Okay. It will be a $2,000 signature bond through pretrial level 2, 2 days of anger management, no further contact with Miss Carter. He can have a one-time escort back to the old Fairburn Road address. If Miss Carter no longer lives there, he can reside there. If Miss Carter is residing there, he must gather his belongings and find someplace else to live in the meantime. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Arnold. Did Mr. Murphy return yet? I mean, Mr. McLean? Okay, yes, Mr. McLean, we were speaking of your client, Ms. Talley, position number 19. The recommendation from pretrial was level 1, and I've gotten to the point where Mr. Sirocco was going to give his presentation. So that's where we are with Ms. Talley's case. Yes, Mr. Sirocco.
Thank you, Your Honor. So this incident took place on September 6th of this year. This was at 1619 Orlando Street, Southwest Atlanta. Law enforcement responded to an ongoing fight dispute. This was after Grady had actually reported that they had received a medical assistance call for a woman who had fallen. Officer made contact with this woman, the victim here, Miss Laisha Givens, excuse me. She explained that the defendant, her significant other and caretaker in a relationship for the past 3 decades, had pushed her to the ground after she'd been sitting outside on the porch and then entered the home. She stated that the defendant pushed her to the ground and told her to stay there, adding that's where dogs belong. And from the incident report that we also subsequently received, she had stated that the defendant then struck her several times with her hands as well. She sustained injuries to her right knee and right hip as a result of the incident. And she was unable to get up for, I believe, a good while. The defendant was subsequently arrested yesterday, I see. The state's recommendation here is a signature bond through pretrial services. We would recommend FIB. We have not spoken with Miss Laisha Givens yet, but we would ask the court sound for her when appropriate. Given that, we are recommending no further contact with Miss Givens, stay away from the 1619 Orlando Street address in Atlanta. No drugs, weapons, or alcohol while out on bond, and we will be looking into the extent of the injuries that she sustained to her hip and her knee. And that is all for the state.
Ms. Givens is on the line and wishes to address the court. Now is your opportunity. Does not appear so. Mr. McLean?
Your Honor, I've been in touch with Ms. Talley's family, and she does have an alternative place to stay if necessary. But we would ask the court to consider that signature bond, of course, and we would ask the court to consider something less extensive at this time if there are any classes to be had. She is she's got a bachelor in economics, and she actually has a commercial driver's license and drives a large vehicle for a living.
Okay. For each battery will be a $2,000 signature bond through pretrial level 1. With a simple battery, $1,000 signature bond through pretrial level 1 makes for a total of a $5,000 signature bond through pretrial level 1. 8 days of anger management, no further contact with Ms. Givens, stay away from the Orlando Street address. She can go back to that address on one occasion with law enforcement to retrieve any belongings. No drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Talley.
Next is position 6, Mr. Duval.
Good afternoon, Mr. Duval. You have been charged in case 25 CR 005588B with battery family violence and simple battery family violence. Is there a history, Mr. Howard?
Seconds. 2020 unlawful assembly dismissed.
Thank you, Ms. Falk.
Yes, Your Honor. This happened September 14th, 2025 at 201 Maury Avenue Southwest. Officers spoke with Deshaun Roberson, excuse me, who stated he was in a verbal altercation with the defendant over an Instagram post. During the dispute, Mr. Roberson stated that the defendant climbed over the bed and began physically attacking him. Officers observed scratches on Mr. Duval's hands. They did speak with, and I apologize, it was Mr. Duval who stated Mr. Roberson had attacked him, but then when they spoke to Mr. Roberson, he stated that Mr. Duval threw an unknown object at him, and that it became lodged in the wall. He stated he tried to distance himself, and then Mr. Duval continued to engage, including pulling on his hair. Mr. Roberson also presented a photo on his phone showing a black eye he had sustained from a previous altercation with this defendant. And on the scene, the officers observed that Mr. Roberson had visible injuries, including a laceration on the inside of his lip, a bleeding right earlobe, which was the result of having been bitten by the defendant, scratches on his hands and feet, and a black eye on the left side. At that point, the officers determined that the injuries to Mr. Duval were defensive in nature, and that the injuries to Mr. Roberson, the victim, were offensive in nature. And they determined that it was the defendant who was the primary aggressor, and he was taken into custody. We did have an opportunity to speak with the victim in this case, Your Honor. When we spoke with him, he did state that they have been together for 1 year. He stated he is not afraid of the defendant. And he did, however, admit that he had sustained injuries such as a bite to his ear and a lacerated lip. He also admitted he had sustained a black eye from a previous injury, from a previous incident involving this defendant. For that reason, we are rating him as high risk on our lethality assessment. We are asking for a $3,000 surety bond, stay away from the address on Maury Avenue. I believe I stated that was 501, but I just need to double check on that. No further contact with the victim in this case. We are also going to ask for FVIP since this is a second occurrence in the year of them living together. And finally, we're going to ask for no alcohol, drugs, or weapons, and that address is 201 Maury Avenue Southwest. At this time, we would like to sound for Mr. Roberson, and that's all for the state.
Mr. Roberson is on the line and wishes to address the court. Now is your opportunity. Doesn't appear so. Ms. Wills?
Thank you, Your Honor. My client virtually has no criminal history. Sorry, I'm unmuted. Has virtually no criminal history. I'm sorry if someone's speaking.
I'm not sure
Okay.
who that was, Ms. Wills. You can continue.
Okay. My client has virtually no criminal history. I would request a signature bond in his case. He does state that the alleged victim is his boyfriend. These are all allegations, and he does adamantly deny all allegations that are being made against him. He does state that the alleged victim was the instigator. and that the residence where the incident occurred is his residence. And so again, I would request for a police escort for him to return to his residence and be allowed to remain there if the alleged victim is not there. Otherwise, then a one-time police escort for him to get his belongings. My client is the one who called law enforcement because, again, it was the alleged victim who was the instigator in this case. My client is employed at Sugar Factory as well as Red Room Bistro, and he also does some acting and modeling.
Mr. Roberson, is
Yes,
that you,
sir.
Miss? Okay, so you're under more on the screen there. So I'm happy to hear from you. I'll need for your face to come more into frame for me. Okay, if you'll raise your right hand for me, please. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. What would you like to tell the court, sir?
I would like to tell the court that was an isolated situation. There was a previous situation that happened, but it was just a total misunderstanding, and it just happened to get too far. But I'm not afraid of him. This is a first time things like that. Like I said, definitely an isolated situation, and I'm currently not at the residence. It is his residence, and if I have to leave for him to come to his home, that is perfectly fine. But he's not a high risk, like where it's not a problem.
Okay, so you're telling the court that you have somewhere else that you're going to reside. So I don't feel comfortable with you all having contact at the present time. So I'm going to order that you have no further contact at this time. Since you're going to go to another residence, I'm going to allow him to stay there. Anything further, Ms. Wills, Ms. Falk?
No, Your Honor.
Okay, thank you for being here this afternoon, Mr. Roberson.
Thank you.
You're welcome. For the
Everybody
battery,
pissed me off.
go ahead and meet them for me, please. For the battery, it will be a $2,000 signature bond through pretrial level 1. For the simple battery, $1,000 signature bond through pretrial level 1 makes for a total of a $3,000 signature bond through pretrial level 1. No further contact with Mr. Roberson. I'm going to give him a police escort to go back to the Mallory Avenue address. If Mr. Roberson has vacated, then he may remain there. If not, he'll have to get his belongings and find someplace else to reside. 3 days of anger management, no drugs, alcohol, weapons while out on bond. Good luck to you, sir.
Next is position 11, Gabrielle Lewis.
Good afternoon. Good afternoon, Ms. Lewis. You have been charged in case 25 CR 005592Y with theft by shoplifting, willful obstruction of law enforcement officers, and possession and use of drug-related objects. Is there a history, Mr. Howard?
It's a third arrest. She got an open arson, second degree, criminal damage to property, second degree, trespass, possession of tools. It's 24 PI 008685. That's all.
Thank you, Ms. Falk.
Yes, Your Honor. This happened at the Dollar General. The defendant entered that location, which was located at 4894 Old National Highway in College Park on September 13th. She was walking around, placed a pair of scissors in the hoodie she was wearing, stole a bottle of water and ate an ice cream sandwich, the value of which was $6. She was taken into custody on scene. The officer, when he tried to take her into custody, she was resisting arrest, pulling away from the officer. She was eventually taken into custody and a pat-down search was conducted on her person. The scissors were located in the front pocket of her hoodie, as well as a pipe that is commonly used for smoking cocaine. The employee, Mr. Jones, did confirm that the scissors had been taken from the store shelves of that Dollar General. As you've heard, the defendant has 2 cases previously within the last 5 years. One was a family violence battery out of South Fulton, and the other was an arson in the 2nd degree and a criminal damage to property. I believe that both cases are still open. If Your Honor will just give me one moment. I believe the 24 PI case is still open
Yeah,
at
that's
this
open.
time.
That's open.
Yeah, that's what I thought. And so, and the 2020 family violence battery was closed. The disposition on that was that the defendant was, and I know it's not directly related, but that case was dismissed. The other case is still open and she is still out on bond on that offense, which was at the end of 2024. We are asking for a $1,500 surety bond, $500 on each count. We're also asking for for a stay away order from that Dollar General, and I believe the address was 4894 Old National Highway. And furthermore, we are asking for no alcohol, drugs, or weapons at this time. That's all for the state.
Thank you. Mr. McLean?
Okay, thank you. Your Honor, Ms. Lewis is 25 years old. She does have social worker contacts. She is residentially challenged at the moment, but she does have somebody who gives her good mail service as a mail drop. And also she emphasizes that she would stay up with her court date by that method. Your Honor, we would ask the court to consider giving the bond as low as possible, a cinch bond if that is possible in this situation, given the nature of the charge. We do intend to have a social worker talk to her about housing and possibly MH.
Your Honor, the state would concur with a social worker visit on this case. We think one is necessary given the circumstances.
Okay. For the theft, it will be a $500 good bond. For each of the other charges, a $250 good bond. Makes for a total of $1,000 good bond. Stay away from the Dollar General on Old National Highway. A social worker visit to assess for BHET and housing. No drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Lewis.
Next is position 8, Mr. Hewlett.
Good afternoon, Mr. Hewlett. You have been charged in case 25 CR 005590E with battery family violence, simple battery family violence, and cruelty to children in the 3rd degree. Is there a history, Mr. Howard?
No.
Thank you. Ms. Falk?
Yes, Your Honor. This incident happened on September 13th of 2025. Officers spoke with Licia Clinksales, who stated that the defendant blocked the doorway of the residence at that location and refused to let her leave the room. As she attempted to leave the room, a physical altercation took place that resulted in visible injuries that were observed to the neck, arm, and leg of Miss Clinksales. Officers also she also stated that this incident took place in front of their 1-year-old son, LH, that she shares with the defendant. This incident occurred at 4420 Rishima Street. My apologies, in Union City. We do acknowledge that this is his first arrest. Let me just check one thing really quickly. We did not have an opportunity to speak with Miss Clinksales in regards to this incident. We are agreeable with an SOB through pretrial services level 1, but we are asking, due to the very little time that has elapsed from the incident to today's date, for a no further contact and a stay away order from that address. We are also would like to sound at this time for Ms. Clink Sales if she is available. That's all for the state.
Ms. Clink Sales is on the line and wishes to address the court. Now is your opportunity. Does not appear so. Ms. Wills?
Thank you, Your Honor. In light of the my client not having any criminal history, I would request a signature bond. I'm in agreement with the state's suggestion of a signature bond. My client does state that the alleged victim was the aggressor in this case. He does deny the allegations as they are stated. And my client does state that he called law enforcement. He is employed. He's a manager at True Green and has been a manager there for the past 4 years and does have some college.
$2,000 signature bond through pretrial level 1, simple battery and cruelty. $1,000 each signature bond through pretrial level 1 makes for a total of a $4,000 signature bond through pretrial level 1. Given that we haven't heard from Ms. Clink Sales, no further contact at this time, and stay away from the residential address. You can go back to that address on one occasion with law enforcement to retrieve any belongings, no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Hewitt.
Next is position 10, Mr. Lee.
Good afternoon, Mr. Lee. You have been charged in case 25 CR 0055918 with simple battery, family violence, and willful obstruction of law enforcement officers. Is there a history, Mr. Howard?
8. On probation out of the cab for robbery. Got to open criminal damage to property, 2nd degree. Obstruction, simple battery. Possession of marijuana. It's 25 PI 000135. 2010 burglary conviction. That's it.
Ms. Falk?
Yes, Your Honor. This incident happened September 14th of 2025. Officers were dispatched to 85 Mount Zion Road Southwest. They spoke with Miss Tanisha Guffey, who stated she was in a verbal altercation with the defendant within the doorway of the apartment unit. The defendant stepped outside and witnessed the officers walking up towards Miss Guffey. Mr. Lee then struck Miss Guffey in the face in front of the officers with an open palm for calling the police. At that point, he fled from the location while the officers were attempting to detain him for the crime they had literally just witnessed. They were able to observe Mr. Lee hiding in some bushes nearby. He began fleeing from the officers again when they approached him, and after a short foot chase, he was finally taken into custody. As you have heard, Mr. Lee is already on probation for a robbery offense in DeKalb County and is currently on bond on an open case here in Fulton County. We are asking and did this in the presence of officers according to the officers' statements. We are asking for a $2,000 surety bond, $1,000 on simple battery, family violence, $1,000 on the willful obstruction of a law enforcement officer. We are also asking for no further contact with the victim in this case and stay away from the address. We did have although we did not have an opportunity to speak with the victim directly, we will say we had an opportunity to listen to the jail calls. And
someone did call me this morning. I'm sorry to cut you off.
Well,
okay.
don't cut her off, Ms. Guffey. I will hear from you in turn. So I'll be with you, ma'am. Thank you. I apologize, Ms. Falk. You can continue.
Thank you. And I will say that she recounted to the defendant in the jail call that he had driven drunk, locked her out, and slapped her in front of the police. And she said that his bruises that he had incurred were from falling while running from the police. So I do just want to point out that there was a discussion involving the incident that the police had also witnessed via the victim in this case when she and the defendant were speaking. We are asking for that $2,000 surety bond. We would like to sound for Ms. Guffey at this time, who does appear eager to contribute her position on this case. And that's all for the state.
Thank you. Yes, Ms. Guffey, the court will hear from you now. If you choose, I'll need for you to unmute yourself and activate your camera for me. Yes, ma'am. Go ahead and unmute yourself.
Hey, how you doing?
Okay. Yeah, I'm doing well. Thank you, Ms. Guffey. If you can raise your right hand for me, please, ma'am. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. What would you like to tell the court, ma'am?
I don't know what the police officer saw because he did not strike me in my face. I was holding my phone like this, talking to the police officer, and he tried to swipe the phone out of my face. And I asked the police officer, I said, "You did just see that, correct?" And he said, "Yes." The police were supposed to be coming to remove him off the property. Whatever he got into it with the police, I guess that was on him. But they was just coming to remove him from the property because he had locked me outside my house. He has no memory of that because he's drunk. Like I think Miss Cassandra when she called me this morning, he has a job. He goes to work. You get what I'm saying? He helps me with not just the kid that is his, but all three of my kids. And he also helps pay daycare. When he's drunk and under the influence, he's a totally different person. He needs help and he don't understand that. But he did not strike me in my face. He tried to take my phone out of my hand and said, "Oh, you really called the police?" That is what he said, but he did not strike me not one time. Did he threaten to while I was on the phone? Yes, he did threaten many of times. But has he ever laid hands physically on me? No.
Okay, and you called the police, Miss Guffey, is that right? Because of,
Yes, I called. Yes, sir, I did.
okay, and has this type of behavior happened before? You're gonna have to pay attention.
One
You're gonna have
time
to,
when
Miss Guffey, this is a court proceeding, so I need for you to stop doing whatever it is that you're doing there and address the court solely, okay? I want to
I
make
just
sure I
said
have.
yes to you.
Okay, well, I don't want you doing anything else, ma'am. You understand what I'm saying? All right,
Okay.
so has this, answer my question, has this ever happened before?
Yes.
Okay, and have you had to call the police before?
Yes.
All right, thank you, Miss Guffey. I appreciate you being here this afternoon. Ms. Falk, do you have any questions?
Yes, Your Honor. Just one follow-up question.
Ms. Guffey, you
Miss
still
Guffey,
need for you to come back for me, Miss Guffey. Okay, unmute yourself right there. Okay, thank you. Go ahead, Ms. Falk.
No problem.
Miss Guffey, you stated the defendant had never hit you before. Is that correct?
Yes.
Do you recall on January 5th, 2025, calling police out because you alleged that the defendant had punched you in the face?
Punch me in the face. The only thing
Yes, January 5th of 2025.
No, ma'am. The only thing he's ever trying to do is take a phone. If he's not deliberately punching or anything. Anything that I've always said while I was on the phone with the police, so that they can hear, he's always trying to take my phone. So that's what's happening. He's never striking me.
And you do understand that the defendant is currently under a condition of bond on a $7,000 surety bond with an order to stay away from you and stay away from the residents at 85 Mount Zion Road from the incident on January 5th, 2025.
No, ma'am, I did not have any recollection of that until he called me on last night and told me. No, I did not.
Thank you, Your Honor. That's all. And Your Honor, I would like the court to take judicial notice of the fact that the defendant is currently out on a $7,000 surety bond with conditions of no further contact with Tynesha Guffey, no weapons, no drugs without a legal prescription, and to stay away from 85 Mount Zion Road in Atlanta. That was signed by Judge Ashley Drake on January 6th of 2025 under 25 PI 000135, which includes a charge of simple battery family violence involving an allegation that he punched Miss Guffey on that incident date. That's all for the state.
Thank you. Mr. McLean?
He is 32 years old. He has a stable mailing address on Logan Street, 30312. He is currently working in a restaurant, and before that, he worked in a different restaurant for 6 years. His employment is stable. He's a high school education. We would ask the court to set the bond as low as possible, a signature bond if possible, but a low surety bond if not.
For each charge will be $1,000 good bond, makes for a total of a $2,000 good bond. No further contact with Ms. Guffey. Stay away from the Mount Zion Road address. If necessary, he can have a one-time escort to retrieve any belongings. Third-party transfer of any minor children for visitation. Alcohol, drug evaluation, and any treatment that's necessary. No drugs, alcohol, weapons while out on bond. Good luck to you, sir.
Next is position 17, Mr. Springfield.
Good afternoon, Mr. Springfield. You have been charged in case 25 CR 005600B with reckless conduct. Is there a history, Mr. Howard?
Well, he was arrested sometime this year in Tennessee. Simple possession, casual exchange, schedule 6, and suspended, and driving with license revoked or canceled. That was a conviction. 2021 OWI, that's operating under the influence. 2015 fade to appear, and he's wanted out of Clarkston. That's all.
Thank you. Mr. Sirocco?
Thank you. And I will add, it appears that he's wanted out of Clarkston for also another failure to appear. And he's currently being held on that. This incident took place September 14th of this year at 2636 Santa Monica Drive, Northwest Atlanta, which I will note is a house in a residential neighborhood. Law enforcement responded to a shots fired call a little before 1:30 in the morning, and the officer was flagged down by the victim here, Mr. Marquand Rimmer. He explained that the defendant had discharged a firearm in his presence and believed that the defendant may have shot at his vehicle. Officer made contact with the defendant, who stated that Mr. Rimmer that he and Mr. Rimmer had a verbal altercation inside the home. I believe that address is the defendant's, and Mr. Rimmer, he claims, told him something along the lines of, "I got something for you." And the defendant did then proceed to admit to discharging his firearm into the air as what he claims are warning shots. In response to that, the officer made contact with a third party, Miss Michelle Rimmer, who is the mother of the defendant's child. She stated she didn't observe the defendant fire shots at Mr. Rimmer per se, but confirmed that the defendant did fire 2 rounds into the air in front of the residence. With this being very concerning behavior, as you know, our office takes firearms cases very seriously. This was fired in a residential neighborhood, and he presents a risk to the community with this sort of behavior. I will note as well, we are looking into a prior out of Wisconsin, which may well be a felony, which would mean he would not be able to own firearms here. We would need to look further into that to confirm that that is the case. But with that, with the circumstances here and also with that FTA that he's being held on. The state's recommendation is a $7,500 surety, no further contact with Marquand Rimmer, surrender any and all firearms to the sheriff's office, no drugs, alcohol, and certainly no weapons to include firearms while out on bond. And if I want to add as well, we have spoken with Mr. Rimmer. He said the defendant is his sister's boyfriend, and that the defendant got upset because the victim would not clean up the kitchen after a birthday party. The defendant was drinking alone and had gotten upset for this reason. He doesn't want any contact with him and wants him to stay away from him, although we don't have his home address. So we would ask for stay away from the victim's address here, as well as ADET, given what Mr. Rimmer has explained to us about the defendant's state of mind and state of being at the time.
Thank you. Mr. McLean?
Your Honor, Mr. Springfield is 36 years old. He has a high school education, and he, for over 10 years, has worked as a home health care person. He takes care of people who are shut in. Your Honor, under these circumstances, I noticed that he already had a $1,000 bond set. If the court feels the FTA spoken of in this session has been confirmed enough to make him ineligible for a signature bond, we would ask for a signature bond, and we do ask for one, but if he's not eligible for it, we'd ask that the $1,000 surety bond remain.
Given that the bond has already been set and remain at $1,000 good bond, no further contact with Mr. Rimmer, stay away from his residential address, relinquish all firearms, no drugs, alcohol, weapons while out on bond. Good luck to you, sir.
Thank you. Nope. So, next is position 9, Mr. Johnston.
Good afternoon, Mr. Johnston. You have been charged in case 25 CR 005593C with driving under the influence of alcohol, less safe, improper erratic lane change, unsafe vehicle or equipment, and failing to secure a load. Is there a history, Mr. Howard?
4. 2017 DUI conviction, 2009 DUI conviction. That's it.
Ms. Falk?
Yes, Your Honor. This incident happened on September 13th of 2025 at around 10:40 p.m. Officers observed were parked at State Bridge Park on State Bridge Road. They were in a fully marked patrol vehicle. They saw a Dodge pickup truck traveling eastbound on State Bridge Road, and they saw the pickup truck veer to the right side of the lane and mount onto the curb with the passenger side of the vehicle. They then came behind the pickup truck, saw the pickup truck again veer to the right side and mount the curb. After the pickup truck then re-entered the roadway, items started to fall off of the back of the pickup truck and land on the roadway. The officer ended up driving over the objects because they were unable to dodge the objects as they were falling into the lane of travel. There were objects like cardboard boxes and miscellaneous trash that was unsecured in the back of the pickup truck falling onto the roadway and causing hazards to the roadway. The officers also observed that the tire of the vehicle, one of the passenger side tires of the vehicle, was completely flat. At that point, the officers initiated a traffic stop. They saw the defendant who was driving. His eyes were watered and bloodshot. Speech was slurred. He was unsteady on his feet when he got out of the vehicle. They did ask him to do a series of tests, the field sobriety tests. He did decline those, as well as the breath and blood test. He declined those as well. The officers also observed numerous scrapes and a large gash on the sidewall of the front passenger tire. and rub marks on all four exterior tires as though he had been scraping them along either the curbs or the side of the road as he was driving. And I again point out, Your Honor, they saw him on at least two occasions leave the roadway completely with the passenger side of the vehicle and mount the curb of the roadway. Due to the fact that this defendant already has two convictions in the past, I believe it was 10 years, at least one was in the last 10 years for driving under the influence. The state does have serious concerns about this defendant's driving. We are going to ask for a $5,000 surety bond on the DUI less safe, $1,000 on each of the remaining charges for a total of an $8,000 surety bond. We're also going to ask for no driving whatsoever during this time, no alcohol, drugs, or weapons. We're further going to ask that the defendant undergo random screens. And that is all for the state. I cannot emphasize enough, Your Honor, how concerning this is that the defendant was driving in this condition and not only causing massive hazards on the roadway by having objects fall off of his car, but also driving and leaving the roadway on at least two occasions that the officers observed.
Thank you, Ms. Wells.
Thank you, Your Honor. While what the state stated might sound concerning, these are allegations, and my client does deny these allegations at this time. He does have limited history. The dates that I noted was 2009 and 2007 were his prior convictions. My client states that he is a software or owns a software consulting firm, and he has owned that company for the past 5 years. He does have a bachelor's from Georgia Tech. He is married. I would ask for a signature bond, and I would also object to restricting his driving or prohibiting him from driving at all. If there are going to be any restrictions, I would ask that he be allowed to drive to work, medical appointments, church, and things of that nature. Thank you.
And for the DUI, it will be a $2,000 good bond. For each of the other charges, a $500 good bond makes for a total of a $3,500 good bond. Alcohol, drug evaluation, and any treatment that's necessary, random screens, no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Johnston.
And Your Honor, you are not going to do any driving restrictions as part of this?
I'll let, if he's to be restricted, I'll let that be another department. So.
Yes, Your Honor.
Disposition 20, Mr. Truitt.
Good afternoon, Mr. Truitt. You have been charged in case 25 CR 005603B with simple battery family violence. Your history, Mr. Howard?
28. 2021 theft by receiving conviction. 2010 trespass conviction. Everything else is older than that. I think I left
Rocco?
Thank you, Your Honor. This incident took place, this was May 2nd, 2024 at 849 Bolton Place, Northwest Atlanta. Law enforcement responded to information on a dispute. The officer met with the victim here, Mr. Daral Hanter. He explained the defendant, who lived at the location but had been kicked out multiple times, had assaulted him with a branch. And he stated they had gotten into a dispute about the living situation there. The defendant got upset, went and picked up a branch, and then proceeded to hit him over the head with it. The defendant was not on scene. Upon the officer's arrival, a warrant was issued, and the defendant was subsequently arrested. This was 2 days ago. I do see, we did speak to him, the victim here. He states he knew the defendant through other people also, and has been seeing him around the neighborhood because he fixes cars. He's, excuse me, he stated that on the day of the incident, the defendant had thought the victim had been messing around with his girlfriend, which was a lie, and that there was a previous incident also where the defendant had to be pinned to the ground for messing with him, and he thought this situation, any hostilities between them were over. but apparently not. He did receive bruises to his person, he states, as well as uh, a concussion from being hit with a stick. We'll be looking into documentation for this and further into those injuries. Because he also went to the hospital, as he states, because he thought he was going to faint subsequent to this incident. He wants no contact with the defendant. He wants the defendant to stay away. So we would be asking here for $1,000 surety on this, given what he was telling us about his prior incident with the defendant. 5 days anger awareness, no further contact with Doral Hanter. We'd be asking for a stay away from 849 Bolton Place in Atlanta, and no drugs, weapons, or alcohol while out on bond. If we could sound from Mr. Hanter at this time. Thank you.
Mr. Hanter is on the line and wishes to address the court. Now is your opportunity. You'll need to unmute yourself there for me, sir. Raise your right hand for me.
Yes, sir.
Yes, do you swear or affirm the testimony you're about to give before this court would be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down, Mr. Hanter. What would you like to tell the court?
Okay, so 2 months, I want to say in June 12th, I did see Mr. Truitt before all of this, and he actually made threats towards me. He said so, he asked me, I got the text message right, hold on, because I had saved it. He was asking me about a warrant that he had, and he basically said, like, if I proceeded with the warrant, he would go, I guess shoot me or whatever the fuck the case may have been.
Given that, Your Honor, the state would be asking then for a $3,000 surety given the risk of witness intimidation. I'm not sure, Your Honor, you're muted.
Let me finish hearing what he's saying, Mr.
Okay.
Sirocco, so that, because I'm not really sure.
And
I've got the incident date down as May 2nd of 2024. Is that incorrect,
yeah,
Mr. Sirocco?
that day.
Okay, hold
No,
on,
no,
hold
that
on, Mr. Hanter. Mr. Sirocco. Can you hear me, Mr. Sirocco?
I can, Judge.
Okay, so May 2nd, 2024, is that the date of what we're talking about, the simple battery?
no,
That's
no,
what
I'm
I
talking
have.
about it. This is a different day. This happened after. This was
Okay,
on
so
June 12th of
hold
this
on,
year.
hold on.
This
I'm
was
getting
June 12th of this.
confused. Mr. Hanter, I'm getting confused. Okay, so let's just talk about, first of all, I want to talk about the simple battery that occurred on May 2nd. Do you have anything that you want to tell me about that?
Okay. Yeah, he had got upset because he thought I thought I'm messing with his woman or lady or whatever, which in fact that's not even his woman. She just a friend of his, but he's obsessed with her. So he got upset about that.
How do you know
Prior to
Mr. How do you
before he
know
actually hit
Mr.
me with the
Truitt?
stick, he tried to stab me. I know him just off of people in the street, like family, friends, stuff like people that know him that help have them work on their car, their houses. He like a handyman.
Okay, and do you live at the Bolton Place address?
Yes, I live over there. See, I
Okay,
was with the house that I was at where the incident occurred was actually a friend of mine's house. He was just over there. He was I guess he was staying there for a while because he was homeless or whatnot, and they were just being good to him. But the one of the ladies that lived there, he was obsessed with her. He believed that was his girlfriend, his wife, whatever. But she doesn't have no romantic relationship with him, never have. And he went off the deep end because me and her, we talk stuff like that. We chill out. So he felt some type of way about that, and he decided he tried to attack me. But the day prior, before that, like he said, I had to pin him down because he wanted to attack me. He tried to swing on me, and it just went from there. So following after that, the next day he came back. I thought everything was good and everything. We supposedly talked it out. Then he just started with the whole situation all over again. He was upset, and that by this time I had enough of it. I told him just basically just going somewhere. I'm not gonna deal with you. So I sit down on the sofa. Next thing I know, somebody, one of the ladies, who I can't remember who it was, somebody came up and had said that he had went and grabbed a knife. So he came back toward the door. By this time, I'm upset. So I'm mad now. So I walked to the door and I see him with the knife. And I asked him, so you gonna grab a knife now? That's what we doing? He tried to stab me with it. We sat there, tussled for a second with the knife. I got the upper hand. I managed to grab the knife. Then he called himself running from me. He went to the front. He went to the front yard. He picked up a stick. I walked up on him. He hit me with the stick.
Okay, all this occurred on May 2nd?
Yes.
Okay, and then you call the police at that time?
Somebody else called the police. I didn't call the police personally.
Okay. When's the last time you saw Mr. Truitt in your neighborhood?
The last time I've seen Mr. Truitt was on May 12th. But that's why I said we have mutual friends. So he popped up over here, well, at this location I'm at right now. He popped up over here, and I just so happened to be here. And he was asking me about the warrant and stuff that he had on him. And he asked me if I was gonna go through with the warrant. And I basically told him, you already know what's going on between me and you. So like, I don't even know why you asking me all that. And he basically was like, okay. So he made like some comments toward me, basically telling me he was gonna shoot me if he go to jail or whatever.
Okay, and this happened in May of 2025?
No, this happened on June 12th of 2025. The other incident happened in 2024, not 2025.
Okay, so the last
So
time
that's why I
the
said
last
there's
time,
been multiple instances since. It's been an instance since that incident happened. There's been an incident since. That's what I'm trying to say.
okay, I understand you. Thank you. Mr. Sirocco, do you have any questions?
No, thank you. That was, well, I guess that was in person that he had threatened you
Yes.
in June. Okay. All right. Thank you.
Okay, I appreciate you
Yes.
being here, Mr. Hunter. Mr. McLean, yes.
No problem.
Your Honor, no questions for Mr. Hunter. Your Honor, Mr. Truitt has a high school education and past that has been to Atlanta Area Tech. For a year, he studied brick masonry. Lately, he has been engaged in cleaning restaurants. He has also done warehouse work. He was engaged in construction, including that brick masonry, for 6 years total. Given the date of this, the allegations, Your Honor, he apparently has an address. He lives with his sister on a southwest. It's a Downs and it's a 30311. And the quadrant of the city for that mailing address and where he actually stays is southwest. So there should be no problem with him staying away from Bolton Place, which from the name of it, I would imagine would be near the water treatment plant, the Bolton area. So we would ask the court to consider a signature bond on this.
May I speak on that as well?
Hold on, Mr. Hunter. Continue, Mr. McLean.
That's all we have. Thank you.
Okay. Yes, Mr. Hunter.
He
has
has family over there in that area. Like he has cousins and stuff like that. So yeah, he does. He's supposed to live with his sister. But like I said, he's a handyman. There's lots of people that know him and ask him to work on cars and stuff like that. So he does come over there to the neighborhood. Like, and as far as like any other jobs, as far as I know, he know people that have jobs and he has put people on the job. But as far as I know, he doesn't have no job.
Okay, well, I'm gonna keep him away from all of the Bolton Place area, okay? All right. All right. Anything further, Mr. Sirocco?
Nothing from the state, Judge. Thank you.
All right. It's going to be a $5,000 signature bond through pretrial level 2. I want him to have a social worker visit to assess for BHET and possible housing issues. Stay away from Bolton Place. I don't want you in that neighborhood, Mr. Truitt. So stay away from all of the Bolton Place, and of course, have no further contact with Mr. Hanker. No drugs, alcohol, weapons while out on bond. All right, good luck to you, sir.
Next is position 18, Mr. Sutton.
Good afternoon, Mr. Sutton. You've been charged in case 25 CR 005601D with reckless conduct and disorderly conduct. Is there a history, Mr. Howard?
First arrest, jail was a recommendation.
Thank you, Mr. Soroka.
Thank you, Your Honor. This incident took place, this was September 14th. So yesterday of this year at 901 Bolton Road Northwest in Atlanta. It's an apartment complex. Law enforcement responded to a report of a drunken, disorderly person and spoke on scene with the victim here, Miss Christina Phillips. She reported that her brother-in-law, the defendant, had become highly intoxicated and started throwing things in and around the room, and then proceeded to pour gasoline in the room, which prompted her to call 911 because they felt unsafe due to the gasoline. The defendant's mother was also on scene and mentioned that her son had a MH or a M disability, and she believes she acted out of a result of the condition. The defendant claimed he cleaned up all the gasoline and was ready to leave. I'm not sure if that's the case. The officer observed that the defendant appeared to be under the influence of alcohol, and he was subsequently arrested here. We have spoken with Miss Phillips. She states that the defendant is her brother-in-law. She does want contact with him and does not want him to stay away. He does have a drinking problem, according to her, and he needs help, and she wants him to receive that help. We're not entirely sure whether this would have escalated any further than it did. I mean, pouring gasoline in an apartment is a scary thing. I'm not sure whether he intended to ignite that gasoline and whether this was going to be something far more horrendous. Out of our concern for that and with the defendant's current issues ongoing, we are asking that the existing bond on the reckless conduct remains set. It's a $1,200 surety. We would ask for an additional $300 surety on the added disorderly conduct charge for a $1,500 total surety. We think no further contact would be appropriate for the time being, and that this could be revisited. This did only take place yesterday. So there hasn't been a sufficient cooling off period. We're asking for alcohol drug evaluation and any recommended treatment if necessary. Social worker visit for BHET. Stay away from the apartment complex at 901 Bolton in Atlanta, and no drugs, weapons, or alcohol while out on bond with random screens as well. If we could sound for Ms. Phillips.
If Ms. Phillips is on the line or wishes to address the court, now is your opportunity. Doesn't appear so. Mr. McLean?
Check mark by the phone numbers in my notes, so I'm thinking maybe one of his other relatives might be on. Is there anybody else here in the Sutton case? Apparently they have not made it onto Zoom. He's 34 years old, Your Honor. He's got, that address is E5 at 901 Bolton. The high school he went to was McNair in DeKalb County, so he's a high school graduate. Given what the facts have been alleged to be about the gasoline and the cleaning up of it, Our concerns, I think, would be met with a signature bond. We would ask the court to consider a signature bond. There's nothing wrong with having a social worker visit, and certainly an ADET. He would object to that. He can get evaluated, no problem.
Does he live at the Bolton Road address or somewhere else, Mr. McLean?
He lives at the 901 Bolton E5. Is the E5 the particular apartment number? Yes.
I believe that's what I have.
Right. Yes,
Okay.
sir.
And does he live with Miss Phillips?
Yes, sir. He does. Yes, sir. Yes, sir.
Okay. All right. I prefer that he is monitored, so it's going to be $1,000 signature bond through pretrial level 2 on each of the charges. Makes for a total of a $2,000 signature bond through pretrial level 2. Do you think he could benefit from ADET, random screens, have a social worker visit to assess for BHET, and no drugs, alcohol, weapons while out on bond? I'll let him go home, and no further violent contact with Miss Phillips. All right. Good luck to you, Mr. Sutton.
Next is position 21, Mr. Whitlow.
Good afternoon, Mr. Whitlow. You have been charged in case 25 CR 005604E with terroristic threats and acts. Is there a history, Mr. Howard?
21. He got an open battery DV case, 25 CR 003 797E. I'm not sure who the judge was on that bond. The same victim is 7,500 good, so that's surrendered. He got an open criminal damage to property, 16 SC 144771, 2019 fate to appear, 2013 burglary conviction, 2013 simple battery conviction.
Thank you. Mrs. Rocco?
Yes, Judge, thank you. This incident took place September 14th of this year. This was at 2024 Stanton Road in East Point. It's the same incident location as the one in the previous incident, for which there is that open case. Law enforcement responded to a domestic dispute call very early in the morning, around, well, it's roughly 6 a.m. The officer went to the apartment and spoke to a juvenile on scene. That juvenile stated that the defendant came to the apartment, yelling, knocking, banging on the door, wanting Miss Kendra's keys. That is Miss Kendra Whitlow, the victim. Their relationship is it's not clear whether they are still married or divorced, because it states in the warrant that she is his ex-wife, and she stated to us that that he is her current husband. But in either case, he continued to yell and bang for them to open the door, according to Miss Whitlow when they spoke with her, and banging, kicking on it, yelling to be let in. He had apparently called her earlier, asking if anyone was there and inquiring why she wasn't answering the phone for him, and then confirmed that she confirmed the defendant showed up yelling and kicking, demanding to be let in. And at that point, when she refused, he threatened he would burn the place down. The juvenile also stated the same here, I believe as well. And it should be noted that the defendant, when he was stopped in his vehicle subsequent to arrest, there was an inventory search of the vehicle, and they found a concealed carry gun holster. I note this because while there were no firearms found in the vehicle, he is a convicted felon. I don't know why he would need a holster. In any case, that open battery family violence case makes this of even more concern to the state. As stated, it's against the same victim, and that involved one of the daughters calling the police because she could hear her mother yelling, "He's choking me," behind a locked door. And at that point, when they had spoken to Miss Whitlow about it, she reported the defendant tried to take her phone, struck her in the face, and began choking her until, as she stated to us in July, that she couldn't breathe, rating this grip 10 out of 10, and she thought he was going to kill her. She had bruises on her neck, face, bleeding as well. And it seemed like this case, as it seems here, that this incident stemmed over uh, potential jealousy over another man involved with the victim or not, but it seems like jealousy is part of this. We will be, you said pre-trial, you said bond was revoked in that case? That was surrendered?
It will be out the court.
Okay. Well, given this not only being the second offense against the same victim in 2 months, but with that roughly 2 months, but with this prior one being a allegations of choking and possible strangulation there, and with this one being not only a threat to her, but to any children that would be in the house. He presents an enormous risk of reoffense here. So the state is very, very concerned. He was ordered for that case by Judge Lawle to have no further contact with Kendra Whitlow and to stay away from 2024 Stanton Road, as well as to undergo or enroll in and complete FFIB. So he's in violation of two different bond conditions here. And just as well, he presents a risk to the children that she has. We've spoken with her, and they have 7 children between them, but they don't share children together, she states to us. She says they were arguing over car keys, and that she was just tired and didn't want to argue. And she does state that she wants contact with her husband and wants him to come home. Uh, we are not okay with that, especially given the previous bond that he's violated. And she states she's not in fear of him and wants him to stay away, which we are also not okay with, given especially this other open case. The state's recommendation here for all of this is a $5,000 cash bond. We are asking for FIP, as well as no further contact with Kendra Whitlow or her children. Stay away from 2024 Stanton Road in East Point. Surrender any and all firearms to the sheriff's office. No drugs, alcohol, and certainly no weapons, to include firearms while out on bond. And if we could sound for Miss Whitlow at this time.
Ms. Kendra Whitlow is on the line and wishes to address the court. Now is your opportunity. I'll need for you to unmute there for me, ma'am. Unmute first. Yes, ma'am. If you raise your right hand for me, do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Correct.
Yes, ma'am. What would you like to tell the court?
I mean, I don't understand okay, when he mentioned something about me with someone else, that's not true. And saying I might not be married. We've been married 8 years. January made 8 years. Like, I understand with the bond condition and everything, but what about when the kids want to be around and like when like how they supposed to? That's why I said with the no contact, it just like be nonviolent. But since y'all say it's the second time, it's nothing I can really do about that. And far as in like staying away, like we still have like appointments like now, like with chiropractor and everything like that. So, but it hasn't like I don't know. It just I'd rather him just get a lower bond if possible.
All right, so Ms. Whitlow, let me explain this to you.
Mm-hmm.
On the other, okay, you have to listen to me.
I didn't hear you.
Well, that's because you're not focusing all your attention with me. All right.
I'm at the chiropractor. Let me get to a quieter room. Let me see if I can even go in that same quieter room. I guess I can go in here. I'm listening.
Okay, and so this is for both of you. Another judge has already ruled that you're to have no contact. No contact means absolutely no contact. Obviously, no personal contact, no phone contact, no internet contact, no social media contact, no contact whatsoever. That was previously ruled in another case. He has violated that because he's been around you. So instead of doing what you've done, you needed to go back and see if you could modify that bond. But because that did not happen, he's in violation. He's going to keep ending up right where he is if he stays around you. Okay.
You said, how do I modify it?
Well, you're going to have to speak with a lawyer about that, but it has not been modified. I'm about to do a no contact, which I will not modify. So you're not going to have to worry about that because until all of this is resolved, you're to have no contact. And you're a grown person. Apparently, you have children that are not grown, and all this is going on around them. You all have to.
We got patient information.
Okay, that should be your first and foremost priority, taking care of those kids and making sure that they're in a safe environment. You understand what I'm saying?
I get exactly what you're saying.
Okay, so as long as you all to try to remain around each other, he's gonna keep ending up back here where he is right now.
I've been trying to like looking into some like anger management classes.
Well, he has also been ordered, he's already been ordered to do family violence intervention. Had he started that and gotten that underway, that could be something that you could present to say, okay, he's working on himself. But if he hasn't started that, then and he's been ordered to do that, then he's not getting any help. You're not getting any help. You're continuing to call the police because of incidents. Your children are, so it's just until you all get yourselves together for your children's sake, you cannot be around each other. Okay. So the longer, and if you do allow him to come around, he's just going to end up right back where he is now. Okay. So just know that. Okay. I appreciate you being here this afternoon, ma'am. Okay. All right, Mr. McLean.
Your Honor, let me ask, what again was the
What again was the what?
incident location?
It is 2024 Stanton Road.
Okay, very good. Thank you. That's helpful to me. Your Honor, the point I want to make there is that we from the defense would note that he's 36. He lives in Decatur, 30032 zip code. His need to come into Fulton County is not Stanton Road. His need to come into Fulton County, should the court allow a bond that he can make, his need to come into Fulton County has to do with a technical school in the Camp Creek area. So there should be no problem in him obeying, now with understanding where places are and that these are court orders. There should be no problem with him staying away from Stanton Road. He just needs to get to his technical school in the Camp Creek area.
Well, that's neither here nor there, Mr. McLean, because we're not even talking about him going to technical school. We're not talking about that part of town. We're talking about 2024 Stanton Road, where he has been told that he can't be and where he apparently was. He can come in and out of Fulton County wherever he wants to go, as far as that goes, so that, him coming in to go to school or whatever, that's neither here nor there. He's to stay away from the Miss Kendra Whitlow and Stanton Road. That address. Okay, so I don't understand the rest of this argument about him needing to come in and out of Fulton County when that's not even what we're talking about.
I'm speaking of the future.
And Your Honor, if I could briefly, there is some discrepancy. I see it's listed in multiple locations as, one address being 2024 Stanton Road, and then in a different location it being 2040 Stanton Road. I would ask that he just stay away from all of Stanton Road in that location, just out of an abundance of caution here. I believe it is 2024, given that is where the previous incident location was, and that was written several times, but out of an abundance of caution, that's what the state would ask for.
Miss Whitlock, are you still with me? Kendra?
Yes.
Is it 2024 Stanton Road where you live?
No,
What's the address?
it's 2040.
Okay.
2040. Okay, so he's to stay away from 2040 Stanton Road and out of an abundance of caution, 2024 Stanton Road, wherever that is as well. Okay, so we're clear on that.
Right. And Your Honor,
Okay.
he's past high school and technical school, currently doing school. He's been an electrician and working on that for 4.5 years and is seeking to further his education there. He has in the past been a forklift operator as well. But no, Your Honor, my point is simply that going forward, he's clear on and has no need to be around Stanton.
Okay, well, he's obviously not to be there, so if he goes there, then he's gonna be in violation again. Yes, anything further, Mr. McLean?
Nothing, Your Honor. Thank you.
All right, it will be a $5,000 cash bond. If he hasn't started that FVIP class, Family Violence Intervention, stay away from, no further contact with Miss Whitlow, stay away from 2024 and 2040 Stanton Road. No drugs, alcohol, weapons while out on bond. Good luck to you, sir.
Next is position Barnes.
Judge, did you order no further contact with Miss Whitlow's children as well? These are ones that she does not share with him. The child heard the threat to burn down the house.
Okay, well, there's no third-party transfer that's ordered, so if there's no third-party transfer, then I'm gonna let another court decide because at this point in time, I don't know what children are his, what children are not his, who they share together. So if there's no third-party transfer and he's not in touch with her, he shouldn't be in touch with the children as well.
All right.
Okay, so can we go off the YouTube, please?